The petitioner, the Honorable Mark Brantley, just did not do enough to stop the violations which occurred during the process leading up to the Nevis Island Assembly elections in 2011. This is the argument that lead counsel for the government side, Senior Counsel Anthony Astaphan, put to the court as he made his final comments to close off the case for the government side. Senior Counsel Astaphan stated over and over that Mr. Brantley should not be granted relief from the court because he should have employed vigilance as a political candidate. In making his argument, he said that Mr. Brantley should have exercised his right to request the revised monthly list for inspection and extraction. Astaphan is claiming that Mr. Brantley did only one thing, and that one thing was to rely on the authority of the Electoral Commission. He has been using the Radix-Gary principle to emphasize the point that since the petitioner knew ahead of time or had the opportunity to be made aware that he has no right to complain about the elections now since it had passed, he stated that Mr. Brantley had the right to go to the court to compel or force the courts to ensure that the registration officer and the supervisor of elections did their duties under the law. During the closing comments of Senior Counsel Astaphan, presiding Judge Justice Lionel Jones on several occasions raised a number of issues with the final arguments for the government side. To the issue of vigilance, Justice Jones questioned whether Parliament would make legislation and an act that outlines the duties and responsibilities of the registration officer and supervisor of elections, but now it's okay to be ignored. On the issue of sending out of notices of objections, Senior Counsel Astaphan asked the court, should the registration officer in this case, Bernadette Lawrence, be faulted because the post office officials did not ensure that the mails reached the person it was intended for? He stated her only responsibility was that she got the notices of objections to the post office on time, and that she did based on evidence. He referred to a number of cases and authorities on the matter to attempt to persuade the court that there are grounds to believe that the receipt of notice was not important. It was at this time that His Lordship Justice Jones S.C. raised issue with this argument, asking why would Parliament enact a law and append a 5-day notice period but don't expect that the person should receive the notice for hearing. Senior Counsel Astaphan told the court that 203 persons not getting notices of objections is not the answer to set aside an election. He continued on speaking to the right to vote and remain registered. He stated that while the right to vote is good, it is subject to acts and regulations, and further commented that there is no absolute right to vote. This he used as he segued into the issue of voters who were reconfirmed but were penalized or removed from the list by the registration officer. His Lordship Justice Jones raised the matter, inquiring why would the law make a provision for individuals to reconfirm then penalize voters when they do so. He asked what was the purpose of the 2007 Act. Senior Counsel Astaphan took him to a case on St. Kitts where 3 names were removed from the list following the reconfirmation process. He was further asked by his lordship, was the amended National Assembly's Act of 2007 used in the process? Senior Counsel Astaphan read to him the judgment, which did not clarify the argument. Another matter raised during the closing arguments of Senior Counsel Astaphan was the May 26, 2011 directive of the Electoral Commission, which ordered the supervisor of elections to restore the list as of January 31, 2011. He stated it was wrong of the petitioner to rely on this directive. Senior Counsel Astaphan argued that the Electoral Commission had no jurisdiction or right to give the supervisor of elections instructions to restore the list and stop hearings, and referred him to the Act which states that the job of the Commission is only to supervise the supervisor. At this time, His Lordship Justice Jones put this question to Senior Counsel Astaphan. If the registration officer was in a bad mood and started removing names arbitrarily from the list, who has the right to oversee and correct this matter? He asked what should happen to this individual. Senior Counsel Astaphan replied, that person should be shot at dawn, which stirred laughter from all in the court, but was quick to add that this was not the case, noting that a procedure was carried out. This case was given a 2-week duration and has gone down to the wire. On Friday, Dr. Henry Stagumba Brown, representing the Honorable Hensley Daniel, will present his closing arguments on behalf of his client. Thereafter, Senior Counsel Douglas Mendes, representing the Honorable Mark Brantley, will provide a reply to the final words of Senior Counsel Astaphan. This will close off the election petition case. No indication of when the judgment will be delivered has been announced.